Thanks, everybody, for joining us today in our final seminar in our 5-part series. And today's seminar is going to be on workplace investigations. In addition to being employment lawyers, Celeste and I spend a lot of our time conducting investigations in schools and universities, as well as for employers of all sizes, public and private. We could both talk about this topic for hours, and we've packed a lot of information in a fast-paced format, which is going to be more of a conversation, our first podcast style seminar.
Think about your favorite podcast and now lower your expectation. I mean, substantively, no, but maybe flow. So work with us here. This format, I think, suits Kathy and I well, because we actually spend a lot of time in each other's offices and on the phone at times, sort of talking about our own sort of logistical issues and things that pop up in the course of our investigations and how we apply things and how we learn through the process. So our hope is to pass along some of those same insights and practice pointers to you in this presentation. The slides are here to guide us and keep Kathy and I on track and make sure that we keep you to your hour. We appreciate your time very much, but we want to also give you something to take with you. We're going to pull out the most important points on these slides so that when you close out of the Zoom today, our goal is that you're going to walk away feeling confident about when to conduct an investigation, about the issues to consider in deciding who should investigate, and of course, the nuts and bolts of working your way through the actual process, which Kathy and I boiled down to 7 steps to get us from intake to resolution. Kathy, when you're asked to perform an investigation, whether for a client of the firm or for a third party, is the objective typically the same? What are you being called on to do when you get that call?
In my experience, the objective is really the same. In so much as almost 100% of the time, my job is to determine whether a company or an organizational policy has been violated, as opposed to whether a law has been violated. It's not a lawsuit. An investigation is very different.
So when you get a call from a client or another entity to engage you in this work, what are you talking to them about right out of the gate? What's the first step?
First thing we talk about is what the specific complaint or concerns are that have been made, and then what policies are being implicated. I always get a copy of the employee handbook, or if it's for a university or a college, the student handbook, and any other relevant policies and stated expectations. I also always ask the client, what do you already know about the situation? Because most often they've already met with either the employee or a student and have some kind of complaint that has been made. We then talk about the process. And you and I, Celeste, are of course familiar with the applicable standards and the questions asked of us. But Celeste, why don't you talk for a minute about the 2 major overarching steps in the process?
I think in almost every investigation, we're called on typically to do 2 things. And the first of that is to decide essentially whether there is sufficient evidence to support the complainant's version of events. The person who's come forward to articulate a concern, we're going to look to see whether there's sufficient evidence. And the standard that we're applying is the preponderance of the evidence standard. So essentially whether it is more likely than not. And to get there, we have to go through witness interviews, documentary evidence, and we'll take you through all those aspects and those steps. But that really is the first step, is the fact gathering part of the process. And then, of course, the second step is to determine whether or not there's been a policy violation. And in the cases where we get called on to do this work, there are sometimes situations where an investigation might be a good idea to really kind of try and figure out what's going on within an organization or within a situation. But there are situations in which an investigation is mandatory and required, and you need to take action. Kathy, can you talk to us about what those situations are and maybe some of the obstacles that you encounter in those?
Sure. Well, matters that require an investigation, like mandatory investigation, are those situations where a complaining party has alleged an equal employment opportunity violation. That's going to include discrimination, harassment, a hostile work environment, sexual harassment, almost always, situations where allegations of retaliation are at play.
And I think one thing I'd like to kind of interject here, particularly in our post-COVID, post-pandemic world, is that and I know Kathy, and I'm sure you all out there who do this work have kind of seen an uptick in cases where people claim or using the phrase, this is a hostile environment, or I'm being harassed. But it's oftentimes really sort of a lack of patience and unwillingness to cooperate or be available, sort of interpersonal dynamics. So sometimes people are misusing the term harassment or hostile, but that's how they're coming forward to HR or to their supervisor. And so sometimes it's not often like revealed until you get into the investigation process. And you have to, as the investigator or the HR person who knows people, you may have to quiet your own thoughts and sort of opinions about the complainant and initiate investigation to get to the point where you thought you might get anyway, but the terms discrimination, harassment, hostile environment, those should generally trigger the formal process that we're talking about today so that you don't run afoul of what is required, even if it ultimately boils down to an interpersonal type of conflict. And that said, there can be a lot of roadblocks created by all the various people involved within your organization or outside of it when you suggest that an investigation might be required or that you otherwise go ahead and initiate investigation. What's your experience in that?
Yeah, we see that all the time, as many of you might as well. For example, a client doesn't actually think an investigation is warranted. Maybe there's one claim, or maybe what's going on, as Celeste said, is what I talk about a lot in my trainings for management training is a toxic workplace. But oftentimes there is that situation where the client doesn't think an investigation is warranted, but maybe we, in our experience, are seeing some red flags and think that maybe we need to start to dig in a little deeper. There's also a lot of times, quite frankly, lack of buy-in from the leadership team. Maybe the HR director, who is, more on the ground and is talking to employees and hearing a lot more things, thinks, yes, there should be an investigation, but the leadership team isn't maybe quite there yet. There's also a fear of retaliation by other employees who may be witnesses. And with this consideration, as well as many others, I'm often talking to the client right out of the gate about interim measures during the course of the investigation. This can include putting an employee who's being accused of harassment or any kind of allegation on a paid or unpaid administrative leave, or separating employees during the investigation. And of course, this is what's really important about having a prompt investigation with Celeste, which Celeste is going to chat and talk about a little bit later. So some of these roadblocks or concerns about optics or retaliation may play into who you have investigate particular allegations. Celeste, let's say you get a call and we have a situation. It probably needs to be investigated. How do you talk to the client about the considerations in who should conduct the investigation? The internal HR team or an outside independent investigator?
I think this is a really important question, and it is something that should be thought through in almost every investigation. A lot of times the first request that I get from a client who may call an existing client of the firm is that I should conduct it, asking me as outside counsel to conduct it. Sometimes that's perfectly fine and appropriate, particularly if the company is large or I don't know and haven't worked with a lot of the people involved personally. If I've never provided counsel rather than other attorneys or departments in my firm that may have. But if I've had a lot of interface with the people who might be involved as witnesses, complainants, reporting parties, I might ultimately be called on to represent the client in an employment action. So I don't want to make myself a witness in that case, which is something Kathy will talk about a little bit more in a second. But sometimes then I work with you, we might hire an outside investigator to navigate a situation like that or guide HR in your own process in doing that. But if you're handling something internally and you're trying to figure out who the best choice is, there's some things you really need to think about. And that is the type of conduct matters. So the person you might call on to investigate a wage claim, an allegation of failure to pay wages or employee theft, might be totally different than a person you would call on to initiate an EEO claim, a claim of harassment. And that bears on the question, this next point about training and effectiveness in a particular matter. So for those claims that require mandatory investigation, special attention should be paid to whether the investigator has the requisite skills and likely effectiveness. And you want to keep in mind the positions of the people involved, the personalities, the backgrounds of the people to be interviewed, and the fact that the investigator may be called as a witness. In the work that Kathy and I do, we are often looking at allegations of sexual harassment and even sexual assault. And, in that respect, Kathy, how important do you think it is to be trauma trained for certain types of matters?
I think it's critical. Not every investigation, fortunately, involves a trauma-based situation, but if it does, the investigator absolutely needs to understand how to approach the person, the issues, and really get them to open up. And sometimes that's very difficult for, let's say, an HR director who knows employees well, or maybe doesn't know them very well, but sees them at work. It's going to be sometimes in that situation more difficult for somebody to open up to somebody about a specific trauma that they've just gone through. So I do believe that trauma-based training is critical, and in a Title IX investigation for universities and colleges, it's required.
Yeah, I agree. And I personally do a lot of work in K through 12 schools, and I can tell you that I've also received training in how to work with children as reporting parties and as witnesses. And I can't just rely on my experience as a mom. I have to, this is really particularized training. And again, to build rapport and build trust, which is really critical in any sort of investigation with whoever you're interviewing. So it's something I think we're always looking for more opportunities for training. And from where you're sitting, if you're the HR person or in-house counsel or whatever your role may be within your organization, if you think, you might benefit from some additional training, I think you should look for those opportunities. And also, as you're thinking about who should investigate and tricky matters, I think the attorney-client privilege issue pops up when we're looking at maybe the existence or likelihood of investigation, or litigation. Kathy, can you kind of speak to sort of the attorney-client issues?
Sure. When we get a call from a client to perform an internal investigation, this issue is really at the forefront. If we conduct the investigation for you, we have to first overcome sometimes the perception that we're biased. But we also have to think through whether litigation is an eventual possibility, because we may want certain correspondence that we have with you about the investigation to be privileged, or avoid potentially disqualifying ourselves from representing you down the road. And this really goes to the importance of clearly establishing the scope of the investigation early on. I mean, one aspect is also, sometimes what happens is a client comes to us and wants to do an investigation, and we then hire a third party to do the investigation. But as counsel, we're overseeing that. Those communications with the outside investigator may be privileged information. They're working for us, and we might have those privileged. But at some point during the investigation, we always are looking at the issue as to, do we want to provide the result of the investigation? And so we will waive that attorney-client privilege. So it's just an issue that is going to be discussed and that we have to work through early on, and then throughout the investigation, thinking about that.
Okay. And this really goes to the importance of clearly establishing the scope of your investigation from the outset. So whether you retain us or you're conducting the investigation yourself, you have to clearly define the role and the task of the investigator. So, as we talked about, there's certain steps, step 1 or step 2. And so we're talking about those things here. So is the investigator simply performing step 1, meaning are they simply being asked to gather facts and sort of conduct interviews and pull information, look at documentary evidence and sort of establish whether or not there's sufficient evidence to show support for the complainant's version of events? Or are we asking the investigator to do that and also determine whether or not there was a violation of school policy, university policy, company policies, expectations? So that would be the second sort of step. Or are we also then asking the investigator to do both of those things and make recommendations as to next steps? And that can be things, for example, like discipline, discharge, etc. So once that scope is defined, then the investigator is going to come up with an investigation plan. And this is really the nuts and bolts of how an investigation is conducted. Again, sort of looking at fact and data gathering. So Kathy, why don't you walk us through, where do we start?
Well, my general approach first is I ask the client to write a letter or an email to the complaining party and the responding parties, advising them that a complaint has been made and that the company has engaged a third-party neutral investigator to conduct the independent investigation and tell the parties who the investigator is. I mean, if I'm hired as an independent investigator, employees don't know who I am. They don't know anything. They're going to know that I'm in a law firm. About 9 out of 10 people will have already, Googled me and seen who I am and what I look like. I come to interviews often and people will say something about my personal history that I realize that, oh yes, they definitely looked me up. So you want to give that information to the employees of who you are. If you're handling it internally, you still have to inform the parties of who's conducting the investigation for the company. Mostly it's going to be your HR director. But you still need to let people know that. Then the investigator communicates with the witnesses directly, and basically you're doing the introduction. And so then at that point, you can start the ball rolling about, the nuts and bolts of scheduling and making sure that people are, available when you call on them. So that first introduction letter, though, is really kind of a critical piece. It sounds pretty administrative, but it's really sort of setting the tone that the company takes complaints of policy allegations very seriously, and that we are doing our very best to conduct a prompt and thorough investigation. So once this notice has been provided to the complaining and the responding parties, Celeste, what do you do next?
So the next thing that I do is I send my own email to each person, to the complaining party, to the responding parties, to witnesses, introducing myself. It's pretty straightforward. I introduce myself and offer some times to set up an interview. It is very common for people to reply back to me asking for all kinds of details about the nature of the complaint, who's involved, who told you what, I don't understand, I haven't gotten enough information, and I always take the call, or set up a time to talk to someone, because again, one of the biggest parts of your job as an investigator is building rapport with people and getting them to be comfortable with you. So I always take the call, but I don't often provide much more information than we need to meet. There are times where offering additional information may certainly be appropriate to sort of put people at ease or have them show up and be prepared to participate. But I'm really sensitive, and I know Kathy is, and as you all should be, around this, sensitivity to issues about retaliation and about, the potential rumor mill, because with respect to retaliation, people are thinking about that. If I come forward, who gave my name? What do you know? What if someone finds out? I don't want to participate. Tell me what you know, So I'm sensitive to those issues, as well as the rumor mill. And the more information I might give one person, they might go share that with another colleague. And now we're getting into a world where we might be impacting the integrity of the investigation. So I really do keep initial correspondence to scheduling and maybe what you need to know. And I prefer to meet with people in general to explain things. But I do, again, appreciate the importance of getting buy-in and building rapport. So you have to be a little bit flexible on this piece. And I know that you appreciate that as well, Kathy. What are some of the first considerations you give in meeting with witnesses and how to make them feel comfortable?
Yeah, well, the right environment and the location is really critical. And for the past 2 years during the pandemic, that has been a particular challenge. But if you're conducting an interview at the workplace, then I really want to make sure that I have a room that I can meet with an employee with that's private, that doesn't have a glass wall that other people can, parade through and see, oh, this employee is meeting with somebody who we don't know who it is. That just starts to get people spinning. And I just want to make sure that, that room is private and that they know that they can speak to me in confidence. So, and most times, an interview might be at the workplace. Sometimes, we are able to have a conference room at a hotel nearby. And so that, helps a lot also. When I do interviews by Zoom, and we all had to get very used to that, there are definitely pros and cons of that. And I think as all of us have gotten more comfortable, we're able to conduct interviews by Zoom that I think do help. And I have, things that I say to make sure that a witness feels comfortable. Like, are you in a room that you won't be interrupted, that is private? During the pandemic, I conducted did a lot of investigations for colleges and universities. And I was asking students very personal questions. There were, I was investigating at the time several sexual assault allegations, and the students were back home in their childhood bedrooms, and I could see the things that they had when they were, in high school still up. And I was just very cognizant of how difficult that must have been, or that maybe their parents were, outside of the room. So we spent a lot of time before we even started in the questions of talking about that. How do you introduce yourself? One other thing I want to mention also is with Zoom and with interviews, I don't record my interviews, but because people are so used to being on a Zoom call and having that record function, I think a lot of people maybe just assume that you might be doing that. So I'm very clear in the very beginning of all of my interviews, whether they're on Zoom or live, that I make it clear that I am not doing that, but that I take very, very careful notes, and that I am, if they were with me in person, they'd see me typing on my laptop and they would know to maybe stop so I could catch up, because I want to make sure that I'm getting down everything that somebody is saying.
And I'd actually like to touch on a couple of those things. I think with respect to Zoom, I think people did get so comfortable with it that now people ask for that a lot. I've also had, even though they're available and working in the office, like, I'd like to participate via Zoom or on the phone. And I have to say that is not my preference. I mean, I think as an investigator, you're trying to get a feel for someone and what they've experienced, and sitting across from them makes a huge difference in my mind in sort of building that rapport and interpreting their body language and sort of how they're reacting to you, and to hand documents to someone. So often if people ask for that, I really often do dig in and say, I really want to meet in person, unless it's a particularly sensitive issue and we're talking about there's some trauma involved and there may be a reason someone's not comfortable.
Yeah, I agree with you. It is definitely better to meet in person, but I find that I have a lot of investigations that people are far away.
Yeah.
And so it's difficult to do that. My practice has been, if I do one interview by Zoom, I do all of them by Zoom.
Okay.
So, and if I do something in person, then unless it's, just a witness that isn't as critical to the investigation, I might do it by Zoom. But I like to have parity and be consistent.
Yeah. And I think that as to the issue about recording, a lot of the work that I do in K through 12 schools and they're public schools. And so it's subject to the Public Records Act. And so I don't record things because that could be subject to public disclosure, where someone to request my file down the road. And I don't want, that sort of sometimes more intimate or upsetting, whatever sort of conversation to be then put out into the public for someone to send off. So I never record my interviews.
So Celeste, how do you introduce yourself when you first walk in the room? And if maybe you have either a complaining party or a responding party often, or even a witness who's reluctant to participate, especially if they know that you're a lawyer.
Yeah,
That definitely raises some red flags for people.
for sure. I think I do typically give nearly the same introduction to all witnesses, explaining my role, sort of as you're saying, for parity, like, so that is everyone gets the same experience. They all understand very clearly who I am and what my job is. And I do come in and talk to them about the two-step process. My job is as a fact finder. I'm the what's going on person. If this is your opportunity to tell me what you've experienced or what you've witnessed or how you feel, and it's because I need to decide, and I explain the standard. I explain that it's, to determine on a more probable than not basis whether or not the complainants, essentially their support for their version of events. And that's a great segue then for saying, that's why this interview is important. And to the extent that you have any information, on your phone, on your computer, documents or exchanges that would shed light on your experience and your version, I need those materials. I want you to send those materials to me. I think that a lot of people, depending on situations, can be reluctant or closed off. And then I know I'm really going to have to work harder and spend more time essentially getting them, to the point where they feel comfortable with me. So sometimes my questions might start more with just appreciating a little bit about their background, and taking some time to kind of get to know them a little bit, so that they do feel a little bit comfortable. And I think with respect to being a lawyer, I think in those cases, I really have to explain why the process is so important to all the parties. Touch on my relationship if it's necessary with the organization. So if I've been asked and they know that I'm the lawyer for the firm or for the organization, or I've been asked to be outside counsel, those are particularly hard, as we talked about, because there is a perception of bias. And in that case, I really sort of have to think through how it could be played out down the road to decide what all is worth sharing at that time. But honestly, I think what happens in some of those cases is the reality of discussion about what happens if you don't participate or don't participate fully. Because in some cases, if employees are like, well, I'm not going to do that. Well, the end of the day, we need that information. They're an employee of the organization. They are essentially required to participate. And so I think it's sort of explaining really what the significance is and why their statement is, their role is so important. So in addition, to sort of thinking through issues about environment and making someone comfortable and building rapport, what do you think best practices are, Kathy, for the actual interview logistics themselves?
Well, it's, as an investigator, it's a very different role than as an employment litigator. We're really asking questions that don't suggest an answer. We really need to be very neutral and professional in tone and treat every party the same. So whether you're getting information from the complaining party, and oftentimes some of our investigations are really difficult and very sensitive issues, but then to treat the responding party with exactly the same openness to get the information, so that we have not, and this is hard because we're human and we've been doing this a long time, but we haven't made any conclusions at all. We are, as Celeste said, gathering the facts and taking in the information. And I have to say that every investigation I've ever done, it comes out differently than what even what I think of at the very beginning. So we're always learning and remaining open-minded. I always learn some new piece of information that I didn't know walking into the interview.
Absolutely.
What other considerations are at play through the timing and the logistics?
I think that when you start thinking about things, particularly in EEO type complaints, there's an obligation really to conduct an investigation promptly. And you want to do that anyway when we talk about issues relating to rumor mill, or there's potential real harm being done. So you want to conduct something promptly, but there are a lot of reasons that things get delayed. Reluctant witnesses, just where you're trying to schedule people and get them on board or get leadership's buy-in, or all the things we talked about earlier. Sometimes there's just getting to the first witness themselves, identifying the scope, getting everything there. It can be kind of a challenge. And then I think for some of the work that we do, where you are like, it's summer break. Like, okay, well
Yes.
now like getting teachers back, with union considerations, they're not on contract, or where are the students and where are we going to meet, if they're not in school, things of that nature. Also think because of some of the work that we do involves allegations of sexual assault, there is often an interplay with sort of the police that, so if there's a police investigation going on simultaneously, we have to work with police, let them know our role, and we don't want to interfere in an active criminal investigation.
But it never delays the school's obligation to investigate.
Absolutely
probably.
not. And that just goes to the whole issue, I think, of communication.
Right.
Really being clear with the people involved, the client, the district, the witnesses, about what some of the delays are, and making that record so that there's no suggestion that you as the investigator didn't respond appropriately or promptly. I think other delays, certainly can be things, expansion of the scope. Sometimes, as you say, like you get into it and you're like, whoa, okay, this just took a turn, or someone just dropped a whoa in the middle of a witness interview, and now all of a sudden we need to really sort of reassess or expand this. And that, of course, can create additional delays, as well as people sort of identifying other witnesses.
In my investigations, and I'm sure as you do too, I always ask at the end of the interview for the complaining party and the responding party, are there other people you would like me to talk to that have relevant information? What do you do, Celeste, if you have somebody says, yes, I have 15 people that I want you to interview?
Okay, well, that often happens for the person who's responding, like to a complaint against them, right? They might say, well, this is ridiculous. I want you to interview everybody in my department. I want you to interview my wife. I want you to interview my best friend. You should also be, and they're identifying people that they believe are character witnesses, or, people, other students who, may have been at this party and may have seen something,
Right.
And you as the investigator really have to think through, again, what the fact-finding process, what are we trying to get to? What was the accusation? What do we have to establish? What, essentially what to show what happened. You may not need to interview all 15 people, and you're not obligated to interview all the people someone asks you to. You may want to consider some of them, though, so that there's no suggestion at the end that, oh, you did not interview these people and I told you and they had information. So you have to really, it's a case-by-case basis, but just because someone suggests you need to go interview 15 people doesn't mean that you need to do it. And again, when you're thinking about the prompt piece, if is this a critical witness, and are they on vacation for 3 weeks? You have to kind of work through those.
And I think we're always mindful of costs.
Yeah,
For
for
because
sure.
investigations can take a life of their own. And so we always have to be mindful of the client's costs, the expenses that are involved with this.
Absolutely.
Yeah.
Beyond sort of the witness interviews, what else are you looking for in your fact-finding process?
Well, I always ask for documentary evidence, and that can be photos or emails, calendar invites.
Have you noticed sort of, particularly in I think the school and collegiate sort of setting, but a little bit about social media and sort of digging on people in that forum? What have you noticed there?
Well, every investigation, whether it's honestly a school environment or an employment environment, contains social media, whether that is Slack threads. I'm just finishing an investigation now that I've gone through, very lengthy Slack thread, where people have had lots of opinions, and social media, team chat, Zoom chats, in the university and school settings. I'm sure you've had the experience of having to deal with Snapchat, where there is no record. I feel like that's been used a little bit less lately.
Yeah.
We kind of really do see the trends of what is going on for all people, employees, and then also students. But every investigation I have involves some social media information, and a lot of that is actually mostly text messages, and a lot of people keep their texts. And then it takes a while to get them all downloaded and sent to you in a form that you can read through. But that's always part of investigation. And I think people are honestly kind of surprised at that sometimes, but always willing to provide the information.
I think on that note too, I think people tend to be more casual, right, with their colleagues over text or over Slack or some sort of social media, where if they were writing a formal email, they don't think about it the same way, but to just like one off somebody on an IM, like an instant message, like a Slack kind of is, it tends to be a little bit less formal. People don't always think it through as much. And so I think, or that who has it, that is it still exists,
Yeah.
you know, and of course it still exists.
And,
we find everything.
And
right?
and I know in the student investigations, we've both had this experience where the allegation is sexual assault, and the comments in text messages are really difficult, and sometimes people will say, "I'm really sorry I did that."
Yeah.
And so we are dealing with that kind of information and evidence all the time. What about the employee or student who wants another person with them in the interview?
Yeah.
How do you deal with that, Celeste?
So this comes up a lot. So some of the work that we do, especially, maybe in schools and unionized workforces, there are certain rights in that regard with respect to whether someone can bring someone with them. And so in a union context, where there's possible discipline that may result as a result of the investigation, an employee has a right to bring union representation to the investigation interview. In other environments, it's not a right, it's not an entitlement. But I think there are certain circumstances where it makes sense. In trauma-informed cases, sometimes, to have a support person for a party who is complaining, has alleged a significant, sexual assault or something of that nature, if they're more comfortable because they're going to bring someone close to them, that may be an exception. There are other situations that may pop up that make sense within your organization to have someone else present who the person feels comfortable with. That's another witness in a sense. But in those cases, as in every case, we're going to talk here in a second, just right here about confidentiality. But I think the more people in the room, right, you have to be really careful about how information gets out and how information gets leaked within the organization. And so I think if you're making if that question comes up, you have to really think through that piece very thoughtfully as to whether or not it makes sense to allow someone. Now, someone may also want to bring a lawyer, and that comes up a lot.
Yeah.
And in that case, it really is a reminder that this is not an adversarial process. An investigation. This is not intended to be, it's not a deposition, right? And so if a lawyer wants to attend, they often come prepared to object and prepared to, really get in the weeds and get involved. They are not allowed to, you do not have to allow anything like that. In some cases, they can sit there. The potted plant.
The potted plant. That's the term of art that is used.
Yeah. So, but they can sit there, but that's often very confusing for the lawyer involved and for the person who's bringing their lawyer. So getting those issues out in the beginning and explaining what they can do in that environment is really critical.
I find mostly they're pretty respectful once you explain that to them. Yeah. With a few exceptions.
Absolutely. And I think all these issues sort of highlight related concerns around issues of confidentiality. Can you talk to us a little bit about confidentiality and privacy issues?
Sure. Questions around confidentiality always come up. When you have a reluctant witness or a complaining party, people are always worried about what is going to be shared with the company and other employees. In our role as an investigator, we can never promise complete confidentiality. It's just unfortunately simply not possible. But we always say, that we take steps to safeguard the confidentiality. We ask witnesses not to share what they've learned in an interview, to respect the integrity of the investigation process. And I always explain that in the beginning of an interview of what the investigation process is and why it's important to participate and to also, not share what you are talking about with other employees. But, that said, I ask witnesses not to share what they learned in the interviews, but I do say that with a light touch. People are going to do it regardless of how much I say. And I don't want people to think that the company is not allowing them to talk about workplace issues. So I tell people, that information is shared on a need to know basis, and that, we're going to not share this widely. But, this can lead to rumors and swirling theories about what's going on. So Celeste, tell me what you do to address the issues about rumors or client communications.
I think kind of further to what you've already said, I think when I'm talking to interviewees about the importance of essentially kind of not sharing and too broadly or certain information, I think I remind them that of a couple of things. One is which the integrity of the investigation is important in the sense that when I meet with the next interviewee, I want that to be an encounter that I've had with someone who doesn't have a whole lot of background noise about what I've asked this other person or what they think the issue is. Oh, she said this, so you better answer, be prepared, whatever. And so I think as I go through the witnesses in a timeline, I just remind each one, like, the integrity of this process relies on part on your participation, and you're treating this with respect and treating it with appropriate confidence. And so I talked about that. I also, as I know, you always address issues of retaliation. And I approach that with everyone to say, including the person who's been accused, right? So a lot of time, the idea of someone who has been accused of bad behavior is that they will go out and retaliate, right, against the person who has potentially, made an allegation against them.
Or other people that are friends with them.
That's exactly right.
Right.
And so when I talk about those issues, I basically say it really is to protect everyone. Because if you're out talking to anybody about it, anything you could do as a eyewitness, as a complaining party, as a responding party, if there's some adverse action that happens as a result of someone's participation and you played a role in it, there's maybe a presumption of retaliation that you have to overcome. So this really, the idea of keeping things close to the vest, I think during the course of an investigation is also to protect everyone from potential issues surrounding retaliation, which can be a completely standalone issue. I mean, as you've seen, we can have a situation, an investigation where you may find there's not sufficient evidence to support the complainant's version of events or a policy violation, but there is a ton of information to show retaliation, because once people found out about it, they started picking sides and ostracizing people and leaving things in their cubicle. And it was like, whoa, wait, hold on. We decided there wasn't an issue, but wow, we found that you engaged in retaliation. So I think really being careful about that stuff. So
I think our job really is to make sure that we go into an investigation and improve the workplace. That's the
right.
ultimate goal.
Yeah.
And we don't want to do more harm. But these
well,
investigations can quickly take a turn and become this toxic workplace that we really do not want to have happen. And so it is really important to, make sure that employees aren't kind of swirling out of control about what the allegations are and what they think should be the part being investigated.
Yeah, and I think we have to be careful too in terms of your own organizational communication, a little bit about, the status of things or who's on leave. There a lot of those things are conversations you're going to want to have with the investigator or with your counsel, whatever, about how you're talking about the investigation with employees who are wondering what's going on. You're not always going to be able to sit down and be like, yes, we put this person on leave, don't worry about it, or you can talk to this person, not that person. So really being attention to sort of those client communications, I think are really important, and thinking that through
Right.
as well. So
Yeah.
Yeah. And I think now we want to talk a little bit, let's say we've interviewed the complaining party, the responding party, key witnesses. Let's look at what our next steps would be. So I know that in my, as we go through this, so we've interviewed people, we've got the documents, now what? Okay, are we done? Like that's kind of the question. Like, am I done? Like, is this process, the fact gathering process, done?
So what do you do next, Celeste?
I think what I do is I look back, I kind of think back through what's being asked of me, right? I go back to the scope and I go back to my plan and I'm like, okay, let's look at if it's morphed at all. And that process is I often like, we'll review my interview notes. I'm looking at documentation. I'm looking for holes, where if I had this fact, would that help me? How do I get there? Okay, that might mean I need to interview this person, or I might need to ask for these emails, or I might need to kind of do some of that to fill the holes in my story. So I'm asking myself if I've missed something.
And one thing I always tell all the witnesses and especially the complaining party and the responding party is that this isn't your only opportunity to talk to me.
That's right.
And at the end of an interview and in the beginning of the interview, I always tell people, you're going to probably leave this interview now and you're going to go back and you're going to think, I should have told Kathy this, or I should have told Celeste this issue and I forgot to do that. We provide our emails, we provide our cell phones often to make sure that people can go back and they can process what we've talked about, which is often a lot and lengthy interviews, and reach out back to us. And there may be opportunities that, in a lot of investigations that you interview the complaining party first, then the responding party says something that you need to follow up with the complaining party again. So
yeah, I think that's a critical point because, I call it like the 3 o'clock in the morning wake up. Like if you wake up at 3 o'clock in the morning and you're like, oh, I forgot to tell Celeste this, I always tell witnesses, feel free. Similarly, I tell everyone I interviewed, I could reach back out to you,
right?
That this is, until the investigation is over, this is a conversation. And so if you think of something, or if I have now interviewed 5 more people, I'm like, I need to come back and, hey, these people put you in this place. Were you there? Or they said, that piece is really critical, that people understand that they can come back to you and you could come back.
And that's filling in the holes in your investigation so that you can kind of take a look and see where you need to follow up.
Absolutely. And I think it goes to the whole idea, I think, that we're both trying to convey is you need to be flexible.
Right.
You can come in with an idea. You might even think from the beginning, well, this looks like a open and shut case. And it's like, no. So be flexible. As we look, to the next slide, Kathy, can you talk about how our clients and HR representatives should maintain investigation materials?
Right. How you keep the documents provided to you by witnesses is really important. The best practice is to maintain a separate file, limiting the access to the materials. So if you, the client, your HR department is conducting the investigation, it should be a separate investigation file. Don't put it in the employee's personnel file. You don't need to, if you interview a witness who's an employee, you don't need to put your interview notes in that employee's personnel file. So it's really kind of maintaining the integrity of a separate confidential investigation file. So your fact gathering is complete. Celeste, tell me, do you always issue a written report, or are there situations where you just do an oral report to a client?
I would say that the vast majority of the work that I do, I provide a written report, and I was at least 90% of the time, especially when I'm doing work again for public schools or it's coming in as a third party neutral. I have no relationship with the organization as a lawyer, or the firm doesn't have that relationship. That's almost 100% of the time, and for good reason, which we'll talk about. You want, down the road, all your work and your findings to be memorialized somewhere, so someone could come back 2-3 years from now and look at that and say, oh, this is what happened, instead of, because if it's just an oral report there and you're not otherwise documenting it, you could have done all this work or reached these conclusions. It's just is that what they said? I think that's what they said. We took action on that, but where's the document? Like, where's?
Especially if there's litigation later.
Absolutely.
Or litigation about a different complaint.
Yeah.
Maybe going back to prior investigations
Yeah.
is really critical.
That's right. And I think even when we are asked to do work though for an existing client of the firm and then serve in this role, sometimes those reports could be, our communication may be more verbal because we're talking about saying, but it's still memorialized in our own correspondence with the client, which is privileged, at some maybe like,
Right.
We're looking at those issues and we're talking about that, like we said before. So I think there needs to be some form of documentation, ideally, but not all, not always, but most of the time. I think things are definitely in writing. And what do your sort of written investigation reports look like?
Yeah. Well, first I identify the parties. I state the scope of the investigation, what the issues were that I'm being asked to investigate. I explain the investigation process, meaning, I talk about who I interviewed and I discuss the evidence that I relied on. And mostly I will actually attach that specific evidence to the investigation report. I then summarize the facts, so the background of the context, and then I discuss credibility issues, because in order to analyze whether a policy has been violated, and I also state what the policy, the company and school policy is that I'm looking at. And then in order to analyze whether the policy violation occurred, I need to assess the credibility of witnesses. And so I make a finding, within my report on all the important issues. And the language is based upon a preponderance of the evidence, I find on a more likely than not basis that X, Y, and Z occurred. And I explain and have analysis to that. I then make a conclusion, that's my findings, as to whether or not a policy was in fact violated. What's your practice, Celeste, in determining whether a policy has been violated? So if you determine that, do you then make recommendations to a client about discipline, or do you just have a fact-finding conclusion?
Right. So I would say my reports look very similar to what Kathy just described. And then in cases where I am serving as a true, sort of third party neutral, someone's just having me come in to do the fact finding and determine a policy violation, I almost never make disciplinary decisions or anything like that. I don't have that relationship with the organization. And honestly, it keeps me more in that third party neutral position, right? Like I'm really here to just make this determination and move on and allow the experts within the organization who have the relationships with people or within the school, the district, to make those determinations. And so most of the time in the work that I do as a third party, I'm not ever opining on discipline. With clients, as we know, like clients of the firm or with whom we have a relationship, sometimes, then sometimes because there's already been some sort of relationship and discussion and looking at the issues involved, it might be asked in that case to say, well, how do we move forward?
Right.
And so it really depends on who is being retained, who's retaining me and for what purpose. And I will say that I think when I'm able to explain, in witness interviews, I will sometimes tell people where I am the third party neutral, like I will not be opining on discipline, that's not my role.
Yeah, I find that mostly, a lot of times, especially the responding party will ask, well, are you going to be making the decision to what happens to me? Because they don't know. They're confused. So we do make that very clear.
Yeah. And I think that
in our
people at ease.
investigations.
Yeah, for sure. So, all right. So we've worked through this whole process of how to gather facts and how to write the report and critical issues. Now what, right? Now, how are the sort of findings and things conveyed to the people involved? Kathy, how do you find that the information should be communicated to the employee?
Yeah, this is a piece that is often missed. You're so busy, having the investigation done, you've got all the employees, interviewed, you're talking to your investigator, and then they make a recommendation and you make a decision about the discipline, whether there is or isn't. But what kind of sometimes gets forgotten is actually kind of that wrap up, what we call a complaint resolution letter. And that's just advising the complaining party. Investigation was conducted, we've made a determination. Now, you don't have to share the specific personnel, what happened, what the discipline was, but you do have to address some of the issues. And, that is different in every case. And, we, often even once you make the decision about the discipline, we help you write that letter. You can't share what another employee's discipline is, even with the complaining party, because that's personnel information. And that's explained and people really do understand that, but we do have to have that wrap up letter so that employees know, the complaining party, the responding party, that the investigation is complete. So what if a complaint reveals a larger systemic issue in the workplace?
Yeah, that's not uncommon.
Right.
And I think like we talked about in terms of being flexible and things can morph and, the investigation may expand. I think so. It's not uncommon to that what seems like an isolated incident reveals a larger issue. Other complainants coming out of the woodwork to maintain that they also had been subjected to harassment by a particular supervisor, for example, and I think in the course of the investigation, people, as we have previewed, and as you probably know, they start talking about it, right? They're talking about other issues in the workplace, and that can result in sometimes some totally like tangential related finding. I came in to investigate X, and it turns out I also, this is now incorporated like intimidation or employee theft or threatened retaliation. So it's not uncommon. And so we can, I think one of the things we do is we revisit whether there's more work to be done and whether that's going to impact the scope of what we're asked to do. Again, issues around interim measures. As things expand, do we have to respond? Does the organization have to respond in looking at other interim measures that maybe need to be taking place to protect people? And, then again, sort of, is the discipline that you may be looking at with respect to one person, is that appropriate given the other concerns? Can we really ignore all this other stuff that popped up because that wasn't what we were here to do in the beginning? Is it really that big a deal? Of course it is. So you need to look at that issue.
So let's talk about it. We have a scenario in the slides, and Celeste, why don't you go through the scenario so that we have in our last few minutes a quick opportunity to apply some of the concepts that we've been talking about.
Okay. So we have a situation where Kelly is transferred to a new location with her employer. And one night she's working late and she overhears her supervisor, Paul, talking to a fellow employee, Amy, on the other side of the office. Paul's talking about what he did the night before, which he notes was to go to a strip club. And Kelly is shocked in hearing this, that Paul would bring this up at work, but she doesn't say anything. And she's noticing he's continuing talking and he's saying that all the women in the office are so unattractive. He needs to get out and see some, quote, hot chicks every once in a while. Kelly hears Paul tell Amy he loves having her at work because she's easy on the eyes. Amy mutters something in response, but from what Kelly can kind of sense and feel is that she's uncomfortable. And then her response is that she's probably offended sort of by this encounter. And as he's leaving the room, she sees Paul touch Amy's lower back. So once Paul leaves, Kelly approaches Amy to discuss the situation and asks her, like, hey, has Paul spoken to you like this before? And she says, I don't know. I can't recall. And she's like, well, have you ever told him that this makes you uncomfortable? And her response is, I can cope. I can handle it. And Kelly suggests that she file a complaint. And Amy says, that's for me to decide. Like, basically, stay out of it. This is not your business. And Kelly says, you know what, you should file a complaint because otherwise it's going to look like you're welcoming these comments. And Amy ignores her and walks off. Kathy, from what we've discussed today, what are some roadblocks and issues you see right away sort of in this scenario?
Well, it's a good one. It's a different one. Here we have a situation where the complainant might actually be a witness to the misconduct. Rather than the person against whom the charges were made. So the person on the receiving end of the conduct appears reluctant. So some questions that, pop up immediately is, if the witness reports, do you still have to conduct the investigation? And yes, your policies are, you've got a zero tolerance policy for sexual harassment. And when we do sexual harassment training, we talk about that. We don't tolerate any kind of investigation. And even if you're a bystander and you observe something, it's everybody's obligation to address the situation and enforce the policies. So given the reporting relationships here, and the scenario doesn't actually say whether people are supervisors or management levels. And so that's something that we also would think about, do you need to put some interim measures into place? And then of course, who do you need to interview, and the concerns about retaliation?
Yeah, and who would be the person to interview? You're looking at all those issues, just like we walked through before, like, identifying the issue, figuring out who's going to be involved in the interview. Are there concerns about retaliation? Who might be witnesses, who might need to participate? So you're looking at all these sorts of issues, but what this one presents, right, is this issue that you might have a situation where someone is potentially in the receiving end of the harassment, but they are not wanting to come forward, the reluctant sort of witness, and what the organizational obligations are.
And that happens a lot, especially with new employees. They don't feel comfortable. They don't want to rock the boat. They don't want to raise issues.
Yeah.
So, all right. Well, this last slide, the 10 mistakes to avoid, sums up the topics that we talked about today. And each one is really a critical aspect of a solid investigation. We really appreciate everybody joining us today. We're happy to take any questions if there are any, and if there's any, I think there's a little bit of time left, last few minutes.
Yeah, at this point, there's no open questions, but if anybody has anything, we're happy to address it. No questions?
No questions.
Okay,
All
okay.
right.
Thank
Thanks,
you,
everybody.
Yeah, thanks for joining us. Bye.
Thank you.